Fernando Castillo de la Torre. Welcome to Digital Markets Research Hub. I wanted to start this conversation with the obvious, with congratulating on publishing the second edition of your magnus opus, which is a must for people dealing with competition, European law in general, and European competition law more specifically, mainly on practical issues, but we understand that theoretical underpinning as provided in the book is remarkable. You co-authored it with your, again, the second edition with Eric Gipini Fournier, and it's published by Edward Elhart. I had an opportunity to examine it, and it's a really great source of information provided from the first hands of people who deal with the substance of cases, and thus its value is hard to overestimate, and there's consensus in our community, of course. But I wanted to start this conversation with inviting you to maybe to provide to us more background, to provide for some, to remind for others the more background information about the functioning of European Commission legal service, please.
Yeah, thank you. Thank you for having me here. It's a real pleasure to be with you today. And it is indeed also maybe an opportunity to explain to a wider audience what we do. I think those who are a bit more in the Brussels bubble know it better, of course, those dealing with litigation, but I think this is not always known outside. I mean, I get confused and people ask me if I'm in the competition, and I have to say, no, I'm not in the competition. It is a different service. So the legal service is a horizontal service covering all the areas of activities of the European Union. It has the main city in Berlaymont, but within, of course, the legal service, while being horizontal, you have different teams. I'm the head of the competition and mergers team. You have 13 teams, thematic teams overall, dealing with other areas. There's one specific for state aids as well, another one for trade, for example. There is on top a bigger, large group of lawyers dealing with the quality of legislation. So basically legislative drafting, basically. Overall, there are more than 400 people working there, and in the thematic teams, as we call them, there are more than 200 lawyers. The work overall is, on the one hand, the one that is visible for most of the public is the litigation, of course. We are in the lead in litigating. We are the agents of the Commission in the different cases before European courts. But there is the other side, of course, the internal legal advice, which is, depending on the area, let's say 50-50, so to say, which is also a bit less visible for the outside world. But that implies, of course, in competition matters that we are closely associated to the administrative process from the beginning to the end. It's not that we take over the case when something has been decided elsewhere. For the litigation, we are actually very involved in inspections, requests for information, statement of objections, etc.
And maybe as a follow-up question, what is the role of competition cases in terms of percentage or proportion of overall EU cases, and maybe quantitatively, but also in terms of their prominence and impact? And also, obviously, there are many interesting questions in terms of the functional mechanics of this such important organism, an immune system of the EU as such. So how do you deliberate? Do you discuss different strategies? Do you see a priori what would be the most plausible outcomes? Is it the creative process, or it's rather more kind of axiomatic endeavor? Many questions, Fernando.
Yeah, I know. I was thinking, oh, that's many questions. Let's start with competition law within EU law and case law, the importance or not. I had the impression a couple of years ago that competition law was becoming a bit of a niche within EU law. Why do I say that? When I studied EU law, competition law was a core part of EU law, in the sense that for me, it was somehow natural that I would spend a few years, I think natural for almost any lawyer within the Commission Legal Service, doing competition law for a part of your career. But little by little, there was a trend on the one hand, of expansion of EU law to new areas, justice and home affairs, we do have privacy, lots of other things, which did not so much exist in the 90s when I started working in EU law. At the same time, the competition law was becoming more and more complex, technical, economic. You also had, in the 2000s, settlement procedures, commitment procedures, therefore quantitatively less litigation. So quantitatively and to some extent qualitatively, case law was becoming a bit of a niche within a much wider set of case law. The number of cases per year was going down. And I also noticed something that to me didn't happen like 30 years ago. I'm too old, sorry. I mean, I'm talking about 30 years ago, was that at the time, really any student of EU law would do competition law. And nowadays I see people who have studied EU law without having a clue about competition law, which to me was somehow impossible 30 years ago because competition law was a very core area of EU law. At the same time, I have noticed over the last couple of years that I think quantitatively, it's not that the cases have increased, but I have noticed that a number of cases have been heard by the Grand Chamber again. It didn't happen for many years. There were very few judgments delivered by the Grand Chamber in the 2010s, so to say. You had Intel, of course, but not much more than that. And then we have had UK Telecoms, Google Shopping is in the Grand Chamber, Eureka in damages, the sports cases in December, Android Auto, we had the hearing the other day. Yesterday, we have a hearing about damages claims in Germany again, ASG2. So somehow competition law is becoming again, much as it was a few years ago, a core part of the work of the Grand Chamber, even at the EC. Why is that so? I think on the one hand, the digital issues are becoming important in the sense that the judges realize that, issues about digital markets are crucial in the economy, and how we have to cope with these issues from the angle of 102, for example, abuse of dominant position. Some of them are becoming very important. I think also you see lots of damages cases being dealt with by the Grand Chamber. I think because they are at the intersection between EU law and national law, enforcement at national level, effectiveness, principle of effectiveness is at stake, etc. There is the realization that is also a very important aspect of EU law. I think you were also asking about how we sort of work internally. That is, I mean, in general, in the legal service being horizontal service, whenever there are issues beyond competition law. Horizontal, of course, we have sort of management meetings where issues are discussed, where they are really important. We have a team which is the institutional team dealing with sort of institutional horizontal questions as well. More concretely about competition law internally, there is quite a lot of debate. I mean, one of the great things of working in the legal service is because you have a lot of a flat hierarchy, unlike DG where you have several layers of bureaucracy. We only have basically director general, me, and then we have all the colleagues. If you're a young lawyer or a more senior lawyer, will be doing the same thing. So there is quite a lot of internal discussion about horizontal issues in competition law, because in the team there isn't so much specialization in the sense that everyone is supposed to be doing a bit of 101, a bit of 102, and a bit of mergers. This has changed a bit with DMA, but that means that it's also very important to ensure the consistency of our own positions. We cannot have a case where we say this is fine, and then in a similar case, it's not fine. So that means that for me, but also for colleagues, we need to talk to each other quite a lot, and I need to be quite hands-on in the way I get into the cases to ensure that, roughly speaking, what we say is consistent across the board on procedural issues, on substantive issues, etc. So there is quite a lot of internal discussions between us in the corridors, in informal meetings. So that's a bit how we work. And with the competition, of course, as I said a bit before, we are very involved in the process. In the administrative procedure and the internal advice part, of course, formally speaking, you have the more formal ways of cooperating. In a public administration, you have, what we call the inter-service consultations. every legal act which is adopted by, or is proposed by the EU competition, rather, has to go through the legal service, to be controlled by the legal service, be it an inspection decision, a decision about confidentiality claims, a decision, of course, a statement of objections, etc., etc. So the outcome or our powers of, let's say, preventing something from being adopted or not, it depends on the type of decisions and the powers and the empowerment to be given to the commissioner. I will not get into that, but basically we are very much involved. That also facilitates the representation in court, because the colleagues normally who are going to litigate later on, they know the case very well because they have followed it before during the administrative procedure. And on that front, of course, I also have to take care of the consistency, strategy. I think part of precisely my litigation experience in the past give me some insight about how to deal with some issues of a strategy vis-a-vis the other party. I was also working at the court, which is, I think, a very good school to learn how judges think and how courts deliberate as well. So what may be more useful in litigation as well as an argument. And I think in terms of, I think you mentioned a bit about anticipating and so on. Yeah, there is a bit of a strategy going on in some cases. It's difficult, let's say, to give you some sort of overall concept, but I think very often we do see problems coming and we try to prevent them. So a part of our work as well is to advise whenever we see an issue that maybe is not so clearly raised by the undertaking, but we see as a possible danger later on, of course, to warn the DG about that, try to correct it so that we don't have the issue. So we need a bit to anticipate, to see the weaknesses of something, to see if there is a possible flaw that can be exploited by the other side, etc., etc. Indeed, that's part of the job.
And you mentioned several interesting things, and one of those is DMA, of course. So did you participate in examining the proposal, the draft, the original draft and further versions, and then the more kind of historiographic question, maybe kind of genealogy of the DMA? We hear this kind of colloquial or a common reflection that the DMA epitomizes the desire, the intentions of the policy make or commission DigiConnect policy makers, which were very difficult to pursue consistently with an ex post modality, and thus it's a kind of a wish list which you consolidate and refine. Of course, we understand that conceptually, whatever the answer would be, we understand that it is the case. But can you somehow say to us that physically, formally, it was the case that you would, through the last 10 or 15 years, you would witness the wish list of the commission, which you, from juristic point of view, would somehow impose a veto, saying that it would be just a ticking bomb?
Yeah, I think in terms of preparation of proposals, the legal service is very much involved again in the preparation of any legislative proposal. The legal service, both us, the competition team, our colleagues in the team dealing with the DigiConnect, eventually, as I said, the legal revisers, or those who ensure the quality of legislation. So actually, I came back to the competition team in 2020, which was precisely a few weeks afterwards. So we were preparing the proposal. It was actually lodged a few months at the end of 2020. So I was personally very involved, of course, in the genesis of the proposal. It was relatively quickly drafted, so to say. Of course, the ideas were there. There was this idea of the new competition instrument. We had to debate whether it was possible as originally, considered, that we had to do something different. So, myself and my colleague, Vittorio De Bucci, who is now registered at the General Court, but at the time was the head of team, who was responsible for the DigiConnect. We were quite instrumental, and we were very personally involved in the debate and the shaping of the proposal, of course, with other colleagues. That's very clear. So we are, as legal service, also very involved in shaping the proposal. That also means we have a discussion with the DGs. Some ideas were, discarded because we thought maybe this is not a good idea. But just to give you a flavor of something, how important it is also to have an overall background, which is not yet in competition law, actually, the idea of having delegated acts actually was coming a bit, I don't think I'm revealing a big secret there, was a bit coming from us. Why? There was an issue about how to ensure that DMA could be adapted in the future. Because of course, you know, this piece of legislation, very quickly you may realize there is something that we can fix here because it's not working well. So the competition, for example, doesn't have delegated acts. So we came with the idea of having delegated acts to try to ensure precisely the possibility to make some adjustments to DMA that is now, of course, in a couple of places in DMA in a somewhat different form. I think the co-legislators wanted to put more criteria, so to say, but the idea, for example, was a bit coming from us to give you. Why? Because both Vittoria and me had seen that in other pieces of legislation we have been, dealing with in the past, which are unrelated to competition law, and we know it is a useful tool precisely to update eventually, in this case, obligations, for example, that's possible. So I forgot the origin. Sorry about yeah. I mean, the origin, as you know, is a bit of a lack of satisfaction about how competition law could be applied in fast-moving digital markets. Process is complex. I'm sure we will a bit discuss about this today in terms of the complexity of the investigation, economic analysis, procedures. So I think part of the reasons for DMA are connected to that. Not so unusual. We have seen it in telecoms, in energy, where eventually the Commission tried to do competition cases, but in order to be more effective, we moved into regulation. There was also a trend that was also one of the reasons. In national law, we were seeing that some member states were concerned about digital giants and they wanted to do things about it. And that's precisely one of the situations where the case law has accepted that the EU can intervene to try to precisely to have a level playing field and not to have different legislations. When we're talking about markets, which are, of course, by nature, go well beyond the member states. So I think that was a bit the problem at the beginning. Also, the realization that there was an issue there, and some member states were already taking the initiative that finally led to this proposal at the end of 2020.
Excellent. Many thanks, Fernando. I have a few follow-up questions, but because we have a block dedicated to DMA, I
Okay.
reserve them for the next part of our conversation. But let us now revert to the book itself. And we know that you ipso facto, ex officio, part of this discussions, which has clear-cut and well-articulated normative position. But yet the book is written, and it is actually written as an objective, didactical textbook-style text, helping us to understand the substance of evidence, proof, and judicial review in competition law and beyond, because you refer to many background information and theories which underpin the entire legal systems rather than their incarnation in competition law only. So maybe you can tell us about the motivation, the main objectives of the book, and how satisfied are you with the second edition?
Yeah, I mean, I'm never satisfied with anything. So from that point of view, I think I always see things that can be improved. But maybe going back to a bit the origins, I think for us, that was in 2009, a workshop in Florence about evidence and judicial review. Both Eric and me attended it. We wrote 2 different papers. And at the time, we discussed writing maybe something together about competition law. And one of the topics we identified as, okay, there is no book about it, was this area. At the same time, issues of evidence in general were becoming central to our daily business in the team, because we are litigating all the time. There were issues of evidence all the time. And yeah, I mean, basically, case law was becoming massive. I mean, at the time in the 2000s, early 2010s, there were lots of cases, in particular in cartel, a bit less so in other areas, but in particular in cartels. And we need to make sense of it, because newcomers couldn't possibly read everything and be aware of everything. So internally, I started already. I mean, that was more my initiative, sort of compendium of case law on evidence, to put it a bit in a systematic way. So in a way, the book reflects a very practical need of knowing the case law, what the case law says in a somewhat systematic way, and making sense of it. Of course, the book was initially thought as, in principle, for practitioners. At the same time, because I'm a bit academic and I cannot just refrain from trying to make sense of things through conceptualized things. There was already, not in every section, some degree of conceptualization of why this is like this and not like that. It is true that this philosophy continues in the second edition. In some respect, we have been eventually going a bit beyond, trying to conceptualize more, but the basis is still quite descriptive or neutral in sense. This is the case law, but of course, trying to make sense of it, because it happens every now and then. You may have different trends in the case law. So I think, read in the first edition, maybe a bit more in the second edition. In some aspects, every now and then, there are more evaluative assessments of certain things, either to be slightly critical of something, sometimes to maybe defend the case law against some criticisms, etc. But clearly, the book is not there to develop a great theory, not a PhD thesis. That is very clear. I think the idea of the book also was, while trying to be conceptually rigorous, to be useful. And I think that was, the main idea in the book.
Indeed. And so let me start with asking on the substance. And one of the pivotal questions underpinning the development or intellectual journey for the reader is to look at the origin of or the nature of EU law, of course, which it is sui generis, and it consists of, to some extent, it transposes into itself, embeds into itself the pedigree of rich juristic cultures which create the EU law. And you offer very nuanced, but I simplify the things as a kind of three examples of how the role of judicial active or judicial discretion or flexibility in evaluating evidence more specifically, but I imagine it can be also extrapolated to judicial discretion more generally. Three great traditions. There are more, but just to simplify things: French, which is more flexibility; German, somewhere in the middle; and Spanish, with being more form oriented and more creative in a sense. I simplify, I imagine. Can you please trace these origins and maybe provide some nuances?
Yeah, I mean, on issues of evidence and judicial discretion, both. I think first on evidence, maybe I think the way we deal with evidence is a very natural one. I mean, it doesn't matter if you're German, Spanish, Italian, or Polish. In common sense terms, when people say they know something, or they make inference all the time, it has nothing to do with the law, so to say. But while most legal systems have become sort of have accepted the principle of what is called the free evaluation of the evidence in principle, the idea that there are very few rules or legal rules on evidence, some legal cultures have become a bit more prescriptive than others. As you were saying, French tradition has been to give more freedom to the judge without any clear rules or standards about what to do, just convincing the judge. Ultime conviction, the conviction ultima. You have other cultures which have, I think there is always quite a lot of freedom. Let's be clear about that. They try to give some tools to the judges, try to be slightly more prescriptive about it, about the degree of conviction you have to get, the full conviction in Germany, while giving some tools about in German law there has been some development about what is Indizien Anscheinbeweis. So to try to give the judges some tools to conceptualize issues they deal with without, again, being too prescriptive. Every now and then, of course, you may have a specific law saying that this piece of evidence or this document is necessary in a way that is possible. You also have a trend of trying to be more rational in the examination of evidence. I think this is, of course, a more general academic trend that is a bit reflected in the Spanish tradition, at least in the law. I make a difference in all these countries between the academia, which very often converges around some ideas, and then the legal culture of each country. Yeah? For example, in theory, Spanish law would tend to be sort of introduce rationality elements in the assessment. Whether this actually has a clear impact in the daily life of the judges and decisions, I'm less sure about that. But in theory, there is this element of rationality that is being included in the assessment. We could, I mean, I'd have loved to go into other legal system. There is, for example, in Sweden, a big tradition of on the laws of evidence, of Ekelöf being so the leading figure, and there has been quite a lot of literature in Sweden about evidence and big tradition. I mean, I don't speak Swedish, therefore I couldn't get into that. But I think overall, the picture, which is the one that is later on translated into EU law, is one of quite a lot of freedom with some soft, if you want, rules, with some systems being slightly more prescriptive and giving more tools to the judge, whereas others eventually leaving almost full freedom to the judge to decide in conscience, so to say, what is proven or not. I mean, when, of course, at the end, EU law, the problem with EU law, it's not a problem, it's in the nature of EU law, it's an evolving animal, and very often you don't have rules for this. So you have to import concepts developed in national culture. And I think one that I find particularly interesting, and I think it reflects a lot the current way in which evidence is being dealt with by judges, is the duty to state reasons as a way to rationalize the process. I think we cover in the book this idea of overcoming subjectivism, and I see general court judgments becoming longer and longer and longer, some of them having an extremely detailed assessment of individual pieces of evidence. Not always, it depends on the case, but you see that very frequently. When I compare it to national judgments, I see judges in Luxembourg very often going well beyond what one can see at national level, which is a bit more, less detail. I mean, there is an overall assessment. The judge will say, this, but it will be shorter somehow without getting eventually into more rationalizing why I think this document is probative or not probative. I think that's, and I think you were mentioning a bit judicial discretion, which is, of course, I cannot really, there are lots of theories about judicial discretion in general, as you know. I think how the judges will eventually exercise this perceived discretion in EU law will, to some extent, reflect the multiplicity of legal culture. So it's very difficult on that front to have an overall view. I think that unlike evidence, where evidence somehow inevitably you will have to rely on the legal traditions of member states, EU law, because it is a system that is in some ways incomplete in the sense that it doesn't cover all areas, and because it relies for its enforcement in national law, but also because there are lots of gaps. I mean, we don't have a code of administrative procedure, for example. So necessarily, at least what one could call normative discretion, the judges are more creative. I mean, it's very clear, and there are lots of books written about whether the ECJ has been too creative because, in pursuance of the idea of European integration, etc. So necessarily because you will have eventually questions of law that do not have a clear answer in a text, in a provision that says this is like this. I think there is more room for creativity in in judging, for judicial discretion when it comes to even in the interpretation of the law. How this plays into competition law, I have been thinking about that. I think traditionally, there has been, also in general in EU law, because the Commission is perceived as the guardian of the treaties, there has been very often a sort of dialogue between the court and the Commission, as somehow, we always intervene in preliminary references, we are sort of amicus curiae all the time, we are interacting with the court. Some developments are proposed by the Commission. Very often when there is a legal issue, judges want to hear what the Commission thinks in the first place. Sometimes, putting questions all the time at the hearing. So there is a dialogue there. And I think at normative level, even the judges will hear very attentively what the Commission has to say. I think it also translates in competition law. As you know, very often we have adopted guidelines on 101, 3, on mergers, horizontal, non-horizontal, and you can see that even, and it depends a bit on the tradition. Many judges will give these soft law documents some value as okay, because there is case law going back to the 70s, but later as well in Masterfood, for example, where the court recalls that the Commission is still the one guiding competition policy somehow. So there is this policy role that some judges will try to take into account. Not necessarily all judges, and that is a very interesting cultural thing as well. As you know, in some countries within the EU, competition law it's not, they don't review an administrative decision, but the authority has to go to the judge. It's the judge who decides. So in Sweden, in Austria, in Ireland, maybe in other countries. And I see when I talk to judges, you will have those who eventually will give more deference to the Commission because that is a bit more into their own legal culture. And others who come from this type of country where the judge decides, who will be a bit more reluctant to say, yeah, I'm used to the one who decides the case. So I will be eventually less deferential to the Commission. And that you see in different judgments as well. I think at the end of the day, of course, because of appeals, some common criteria will have to be set out. And as you know, the ECJ sometimes has set aside some judgments of the General Court because they went too far into controlling, into reviewing the Commission decision. So there is this idea of judicial discretion, let's say, being there, but eventually in particular in competition law, taking into account the Commission views at more normative level. And then, of course, there is the issue of more cognitive level and the specificities of the case, not so much about the law, but eventually also there is a big debate about that, to what extent, the judges have to be differential in some complex economic assessments, etc.
This is really amazing. So I wonder then, Fernando, if we can talk, of course, we understand that when adjudicating on a specific case, as a judge, your mind should be focused on solving the real problem. You're not philosophizing, you're not theorizing about things. You're focused on a specific set of circumstances. But in the same time, for example, in competition cases, you see both parties are super heavyweight athletes, and they can thematize, problematize, emphasize, accentuate different aspects. So often it might be a 50-50 case where both meet the minimum threshold of legality, validity, and factual correctness. And the element of discretion is in one way or another is present in the judge's mind. And there are different traditions. Some would consider you Judge Hercules, who would somehow think what is best for society as a kind of the wisest representative authority. And thus there must be some continuity in thinking. Others would say, again, focused on case, more inductive than deductive. Is there any such thing as institutional memory? Because we know that the courts do play de facto a prominent role in shaping EU law and EU integration project more generally, but is it just a spontaneous exercise, or there is some rationality behind it?
Well, my own perception is that it is to some extent spontaneous, but it's a process that it's not because it's spontaneous, it's totally unguided, I think. But there is an iterative process of, court having many chambers, of trial and error, if you want, in the sense that you will have one chamber deciding something, goes on appeal. I think that the system of appeals and ultimately the grand chamber is the one that will be guiding the process. But there is a bit of trial and error or spontaneous situations. And I think, the bottom line is that for the interpretation of the law, the judges are fully competent, of course. But we know that competition law is not something that is black and white. 102 is vaguely formulated, 101, same thing. Even with mergers, we know that the criteria, significant impediment of effective competition. What is that? Then you will still have, because it's vaguely formulated on purpose, because of course you cannot capture all possible or anticipate all possible issues that may be problematic. So necessarily the law has to be vague, open textured. Then you try to flesh out, the theories of harm in guidelines, etc. But you will have in this interaction, we have some judges who are a bit more comfortable about following guidelines, others who are less comfortable because they think, oh, I'm the judge, I'm the one who decides. So I think it is sort of a mixture of an iterative process, which is to some extent spontaneous. As I said, different outcomes in different cases may be the result of their own perception of the judges in their own role and their own interpretation of the law. But then, of course, there is some guidance. I think at the end of the day, through appeals and even in some cases the grand chamber, we have, for example, in CK Telecom, there was a grand chamber case that had to guide again what was overall the right interpretation of some concepts in the area of mergers. It is a long process and sometimes very frustrating in the sense that we have to provide legal advice internally. I was faced with a situation where the only case law I had was two different judgments that were saying the opposite. What do I do in that situation? I say, what is the standard? I don't know. Then basically you have to take a risk. You have to bet somehow that in the future it's going to be this case law that is going to be followed instead of these other case law. So it can be difficult because also these cases take time. They're complex, typically more than others. So first instance appeals overall, in the first instance on the appeal, you easily have 6-7 years. And the case law may change. We saw in Intel the clarification, as the court called it, which obviously disrupted somehow a bit some of the pending cases as well. So, yeah.
And in this context, I wonder, what do you think about the standard of review which the judges are preparing for us with the DMA? Because we hear voices, and in particular, the president of the General Court, Mark van der Woude, said famously that it will be paradise for lawyers, implying its open textured nature, and obviously it's uncharted water. The room for discretion and for shaping each mechanism is much wider than in more established institutions and areas of EU law. What is your view? How much because it's a decisive question. You can paralyze the entire project with being too scrupulous and go too far. What is your view?
Yeah. Thank you. Mark van der Woude's statement, I think I understand. I try to decode it. I think it is a paradise for lawyers because it's new in the first place. Whenever you have a new piece of legislation, you will have people who have to interpret it and lots of legal advice going on. DMA in particular, because the way it is drafted, you have to read it twice sometimes to make sense of certain provisions. We had recently the first hearing precisely in the DMA case, where obviously some of the judges were struggling, for example, with interpreting recital 23. So yes, objectively it is new, and it will have lots of questions of interpretation. It is also in a context where the lawyers were used to some type of different instrument, 102, which is more case-specific, case-by-case analysis, even if you have, of course, the case law. Here is a bit more prescriptive about things. So the focus is really on the interpretation of some new provisions. the way also DMA functions is not a purely prosecutorial sort of system like regulation number 1, in the sense the only instrument you have is punishment. You have a whole conversation with gatekeepers, be it in specification decisions of Article 8, you have all these compliance reports. So just the machinery of compliance, the compliance functions well, the machinery of compliance is huge. So you have lots of lawyers working there, of course, because this is not just about, let's face it, I mean, over the last years, what these gatekeepers, what we call gatekeepers now, but these companies, we could have had a handful of cases and that was it. Now all of them have to comply with a long list of obligations. For each one, they really have to explain themselves how they are complying with it. So this whole machinery of compliance is also creating a lot of work, because it is unlike the more case-per-case analysis of a situation, a given conduct. Even for Google, there have been a few cases, but it's still a limited set of cases. So I think this sort of constant compliance machinery is something that, of course, will be a paradise for many lawyers. And also, even if the number of gatekeepers is relatively limited, and we're talking about 6 undertakings at the moment, these are big companies with, let's put it that way, deep pockets. That, of course, means that they're happy, or they're used to having to pay quite a lot in legal fees to ensure that they comply with the law. So they will engage several law firms, typically dealing with different aspects. So overall, it is true that in a situation where somehow, in terms of competition law, the number of cases that the Commission could handle was limited because of resources and so on, a few a year. There haven't been many decisions in over the last years in 102, for example. Now all of a sudden you have an instrument that implies many obligations apply, a very specific set of compliance reports have to be provided, compliance functions, and many issues of interpretation. Of course, we are discussing some of them, designations. Soon we will be discussing about compliance. And there we will see. I mean, you were mentioning the judges, what will be the attitude? We don't know yet. I mean, you could have an approach which is more trying to render these obligations very effective. Then, therefore, eventually, potentially using less the anti-circumvention clauses in the instrument. You may have a different approach, maybe more literal, more formalistic about it. It is. I think in terms of discretion, still we have to think that DMA there is to reduce the discretion as well, because instead of having case-by-case assessment that would imply lots of decisions about market definition, dominance, etc., the idea was precisely to reduce our discretion, to have a number of very clear obligations, and the evidence we have to provide is more limited because a number of things are already in the provision. If you do this, this is prohibited. So you have to prove the conduct, but nothing else. So in a way, the DMA is based on a reduction of the discretion, in the sense that we actually want our discretion to be reduced so that we don't have to do many things that we should normally do in a competition case. Of course, even within this reduced discretion of the DMA, there will be issues of how far you have to go into some issues, how many elements you have to take into account. Be it now we are, litigating designations, later on compliance, how much you have to go, how much leeway the Commission will be given on some issues. But still, what is clear is a number of issues have become also irrelevant. So we don't have to look at that. That is, of course, some people are uncomfortable about that. Those who are used to competition law, they think competition law is a perfect instrument because it's so sophisticated, case-per-case assessment. They may think DMA is too blunt, and legislation by nature is too blunt because it generalizes. It says, I put a general rule. And that is a bit blunt, and some people don't like it because it's too blunt and it's not sufficiently sophisticated. But this is a trade-off of the legislator, who, of course, has to put on the one hand on the balance effectiveness. We know that some of these cases, if they are run as a normal competition case, take too long. We have limited resources, and on the other hand, try to go quick. And try to go quick means to have a rule across the board that may imply in some cases that on a case-for-case basis, some people may think, oh, it's not justified in this case. But that's the normal thing legislators do. We have to generalize and establish general rules as a trade-off. Huh?
But how would you see then the overall mission? What is decoded with this fairness and contestability as a medium-term objective? Because we can identify two antagonistic supporting camps of the DMA. One would say that the more the better somehow, that the mission of the DMA is to make European digital markets more fair, transparent, accountable, contestable ultimately, but we do it by forcing more and more obedient compliance with obligations. So the more instances of non-compliance we open, publicly or privately, the more instances of non-compliance we deter, the more instances of compliance we encourage, the better markets become. That would be the more kind of idealist or more traditional camp. And another more cynical one would say that, well, we have only a handful of people enforcing it, and the catalog of obligation is kind of not hodgepodge, but it's kind of a list of different things which you can incentivize and go deeper. You can establish several layers of non-compliance if your mind is creative enough and if situation forces you to do so. And thus is more selective enforcement and not driven by the more the better narrative, but a more targeted, more focused mechanism. And the second modality somehow envisages the exclusivity of the Commission, because otherwise we would have leniency paradox if we design the low-hanging fruit to speed up the process and facilitate limited resources, but it is only for the Commission. If we give it to all the parties potentially who are of potential interest to litigate for their own subjective, very legitimate benefits, we would somehow caricaturize the whole idea of the DMA. These are two polar views. Where would you position more prudent one, in some way in between, or associated to one or another?
Probably somewhere in between. I don't think that the more cases of non-compliance, the better. I think the ultimate objective is everyone compliant. Ideally, in an ideal world, you don't open any non-compliance case. Huh? Everyone would. That's why there is a lot of emphasis in all these compliance report, compliance function. The idea that it's for the gatekeeper to prove compliance. So very actively try to avoid having into fines and sanctions. But of course, that is the ideal. I'm not sure there is a sort of drive that we really have to have cases. I think that if there is the conviction that it is functioning in the sense that the consumers, that there is compliance and the consumers see this compliance, you don't need many cases. Inevitably, however, some of the provisions are being subject to slightly different interpretations by gatekeepers and the Commission. So somehow, yes, it may happen indeed that we will have cases of non-compliance because DMA, some obligations of DMA at least, is really touching on the essential aspects of the business models of some gatekeepers. And yeah, they are unhappy about that. So there will be a tendency by some gatekeepers to do what we could call a minimalistic interpretation of the obligation on the DMA. The Commission may have a different view. I think what is, and the discussion in general is how far the Commission could go into having a maximalistic interpretation, let's put it that way, trying to render each and every obligation effective, and avoiding the problem of, what appears to be a cosmetic compliance, but in reality, you don't see any changes in the market because actually this is just a very cosmetic compliance. That is something, a debate we are having and we will have soon. So inevitably, I think it's somewhere in the middle because I'm not sure that we are, as a Commission, keen on opening as many cases as possible. We have limited resources as well. So there will be necessarily some degree of selection. And the selection, of course, the question is how to decide which cases are more important than others. And there, traditionally we have, when I discuss, not just DMA in general, the issues about what is the case that, well, first you have to be realistic about your own resources, what you can actually do. You cannot open infringement against everyone. Even if you may have a case, it's just not possible because you don't have the people to do it. Even if, of course, we have to prove less things than in a competition case, let's be clear about that. You will have to take into account that this infringement case open, so have a real impact on the market, on the consumers. For example, is this a case that I'm interested in running because it is important to establish a precedent here? In some cases, the interest of running the case is because they are legally important, because what is at stake is an interpretative issue that is of systemic importance, or well beyond maybe the specificities of the case. You may be running a case that appears to be limited in nature, maybe not very impactful, but it's very legally interesting to establish a precedent that may be valuable for other cases. So we will see. As you know, a number of proceedings have been open. We are still in the very early stages, and we are still internal conversations and external ones, of course, about this whole thing. I think, as I said, and I always have to remind again, it's a very specific animal. You have DMA. The idea is trying to avoid, if possible, of course, the punishment at the end. That's why you have all this compliance mechanism, workshops with stakeholders where people talk to each other. We don't have those in mergers or 101, 102. Still, you will have issues, as I said, because some gatekeepers, they feel some obligation are really touching on very fundamental issues of the business model, and they're unhappy about that. One of them is even challenging one specific provision of DMA. So that's the case of Apple, Article 6.7. Why? Because they feel that it's really touching upon their business model. So we will see. I think it's as a public administration, it's never in extremes. So typically we're trying to be in the middle, but there is of course a debate about this issue.
And yet another debate. We just last week had a conversation with Jens Uwe Frank, professor from Mannheim, who examines the mechanism of anti-circumvention clause of Article 13 of the DMA. And we know that this is not a novelty of the DMA. It's in EU legal mechanism which has its established pedigree, at least in legislation. So I wanted to ask you, how do you expect it to be exercised? Because again, here we have two camps. One say a story where, well, digital markets are so flexible and so rapidly evolving, and 1,001 way to comply with the letter of law without delivering what you are expected to deliver. That would be the one camp, endorsing anti-circumvention. Another one would say, but look, if you comply with the letter of law, and then you are being accused of not complying with what is somehow anticipated, isn't it in itself a little bit juristically a step too far? And then obviously the truth in the middle, but where precisely in the middle in your view?
I think again we are in the earliest stages, but of course, indeed, these are conversations we are having at the moment about when really is Article 13 to be applied or not. There are precedents in EU law, generally speaking, about. We even have it nowadays in all instruments. We have, I think, in the foreign subsidies regulation, there is an anti-circumvention as well. We had it, of course, in the past in anti-dumping, anti-subsidies. We have in the carbon adjustment mechanism. So everywhere nowadays, whenever you have a new piece of legislation which is dealing with something that is a bit new, in the sense that it's the first time we do something, you try to make sure that nothing escapes you. And talking about digital, of course, even if you try to be as specifically as possible in a piece of legislation, you have the feeling that somewhere, these gatekeepers will manage to do something that appears to be compliant, cosmetically, formally, but will achieve the same aim. And I think that was a bit the idea behind. It was already in the original proposal. The provision was shorter than we see now. To try to cover that type of situation. Already, I think there was a bit of something in some competition decisions. Very often, at the end of a competition decision, in the article, you will have this cease and desist order that also says that you shouldn't be doing something that has the equivalent effect or something like that. So the idea of trying to capture eventually in competition decisions, prohibiting a conduct in the future that may not be 100% identical, but it's so similar that it produces the same effect, was somewhere there. And that was a bit the spirit. How this is going to be applied, it's too early to say. I think they're a bit, you say the two camps indeed. I think the provision is there. So it is just, the question is whether actually by having an interpretation of the obligation of Article 5, 6, or 7, which is already broad enough and takes into account the principle of effectiveness somehow, you may not need to go to Article 13. That is one approach. So actually, in the cases, you can just run a case of breach of Article whatever 5, 1 of 5, 3, 5, whatever, without having to use 13. Or you have the feeling that the risk is that, if you go to court, maybe the judges will think, oh, you are making a very wide interpretation of the law, and that's not possible under Article whatever, 5.2 alone. Maybe you could have to use Article 13. Should we directly use Article 13 just in case, for example? It's the type of things, of course, we are debating at the moment, and I cannot provide you any clear answer also because we are not there yet. We have just open proceedings. So I think, but it's true that maybe in a few months when we have, and if we have, of course, because in the meantime the issue may be solved, a final decision, we may have to take a view about these topics. I think at the moment, certainly, generally speaking, people here in the Commission don't want to take a very minimalistic view of the obligation. So already, I think the idea is to have more teleological, if you want, effective interpretation of the provisions. But there are limits to that, because sometimes you have practices that even if you try to stretch a little bit the interpretation, it's doubtful, and maybe you want to use Article 13. But indeed, in some sort of gray areas of the law, 13 is useful. And yeah, I'm sure one day we will have some litigation about that in case really we have these practices where you have the gatekeeper and the Commission having very different views about how to interpret the provision at issue. The provision meaning 5, 6, or 7.
Exactly. And I think we are not here interested in clear answers. The journey, the intellectual journey which you provide in itself is so informative and so fruitful, fertile source of further thinking for our academic cluster focused on the DMA implementation. This what matters most. And thank you very much for this, Fernando. So another question which underpins the overall discourse, so to say, concerns the raising technicalities of the procedure in general, and this is a common trend. So I wanted maybe a few sub questions, if time permits. Who was the main driver there? Because again, we have two camps. One say that it's the defense bar who somehow tries to refer to econometrics and all this kind of interpreting, making the judge feeling as an emperor is not closed, essentially saying, well, okay, I don't understand it, and I refer to a summary which provides in more approachable fashion what all this colorful graph and formulas expect me to understand. And yet another one saying that, well, it's if the stakes are so high and there is no other way, then and the scope for defense is limited, you try to escalate all these small avenues and to use them in full because that's your legitimate right. The next sub question concerns the role of fundamental right, how instrumentalized this mechanism becomes in competition and EU law proceeding more generally. And the third sub question, if this is not enough, concerns our sister regime or EU sister regime, the UK. I know we have this kind of gentleman agreement not to the officials from these two sister jurisdictions not to comment on technicalities, but we have in the UK in the DMCCA the mechanism of mandatory efficiency defense in one of the institutions, namely when we talk about conduct requirements, and the Commission was very vigilant, trying to avoid accepting or implementing any instance of efficiency defense in the DMA. Do you think it's a huge relief for the Commission not to have it? Let's put it this way.
Yeah, maybe maybe I will start with the last question and maybe go a bit backwards. I think the lack of efficiency defense was, of course, done on purpose. I think that if we had included some sort of on top of the obligation, some sort of defenses beyond what is there, I mean, there's some possibility of suspension of obligations, as you know, security reasons that you can eventually be exempted, but not the more traditional sort of, okay, the practice may be prohibited, but it's good for mankind beyond that. Huh? That was done on purpose. I think that because if we had that, we would have just reopened the typical debate we have in 102 by the back door. 102 requires a number of things, more economics, more that would be a given ground to a debate and a scope of an investigation that would be very similar, because of course they would come back with what are the effects of the practice. They would try to show there are no effects, and if there are no effects, a small, I mean, insofar as in 102 case you put in balance anti-competitive and pro-competitive things, if you sort of diminish the anti-competitive, then a little bit of efficiency, they'll say, yeah, I mean, it's true the efficiencies are small, but actually, if you have a look at my case, there is no even an effect. So basically, you got to reopen the debate to one that we already have and we wanted to avoid. So I think that is a very on purpose. That may, of course, lead to the criticism, as I said, okay, legislation is a bit too blunt in the sense, okay, across the board, I prohibit this. Yes, I mean, that is what is laws are about. Very often, many laws, regulations, they put the rule, and it may be that in a given case, a rule that applies across the board in a given situation may lead to less than optimal results in general. But that's the rule, the role of rules in general, I think, in the legal system. Then it will be at the time of enforcement, but eventually the enforcer, the commission, will bear in mind eventually, the infringements that it will perceive as more serious than others in selecting these cases. But I think it's because a lot of the community which is dealing with DMA comes from competition law. They have difficulties in accepting that, the democratic process may lead to laws that are applied across the board and may lead in some specific cases to results which are a bit blunt. But I think it's done on purpose, precisely. It is a trade-off between different interests that the legislator had in mind. It thought that it was overall much better to have clear-cut rules applying across the board, and that require less resources to be applied are subject to clear-cut criteria rather than having something that eventually opens everything up. That is one thing. On fundamental rights, clearly, in general, maybe in competition law and later on if they may have a rule, some role to play in DMA. I think competition law typically has been an area where fundamental rights have been very important. Also because historically, also even within the evolution of EU law, because competition law was the first area where the Commission had, almost the first area, implementing powers. And some of them, powers of inquiry in the 70s, was the only area where the Commission made inquiries. Nowadays we have other areas, but at the time, so quickly, of course, issues of privacy of undertaking with the inspections, self-incrimination, legal professional privilege, when they appeared in the case go rather quickly. There was also the only area where the Commission could impose a sanction. Of course, we had some powers in staff cases, in agriculture, but they were not as intrusive eventually as competition law. I think generally speaking, of course, competition law has been very important in the definition of some principles of EU law and on fundamental rights. But I think there has been still a recent evolution a bit, going in a direction of even taking that further, because traditionally it was measures of inquiry. Now we have cases like in Intel and Sen, where, as you know, the court, the clarification in Intel came from the, and this is even developed in Sen and Unilever. The substance of the law is clarified relying on a procedural principle, the right to be heard. The court says, because of the duty of impartial examination of the right to be heard, you cannot just say that, there is a presumption of effect here without engaging with the arguments of the party. So the court changes a bit the substantive law by relying on procedural principles, which means that the law, substantive law, becomes a bit unclear, and law is transformed into a process rather. But we can see that in other areas of fundamental rights. At the moment, privacy is becoming quite important. Nowadays, we have a number of pending cases about inspections, about a request for information. There is, of course, the meta judgment last year. There is an appeal pending, but it's a very interesting saga and interim measures, the Vivendi Lagardère on gun jumping and request for information. We have a few preliminary references from Bulgaria and Portugal on privacy during inspections, about emails, private apps, which are used in the professional laptop. That is, again, a sort of another avenue where it's becoming important, but also I think in general, case law is becoming more sensitive to fundamental rights. We saw an interesting development about the presumption of innocence in HSBC, about cases where you have statements during the proceedings that may indicate that the commission has already made up its mind about, that the undertaking is guilty. And the court, the general court had said, "Oh, this is a sort of procedural issue. It can only lead to the annulment of the decision if it has an outcome, so an impact on the outcome. And because the evidence was good enough to prove the infringement, it didn't have an impact on the outcome." On appeal, the ECJ said, no, this is an error of law, because this approach whereby procedural guarantees can only lead to the annulment if they change the outcome concerns other issues, but if there is a breach of presumption of innocence, it's so important that in some cases may lead to the annulment of the decision, even if theoretically, you can prove your case. So you see a case law becoming more sensitive to this issue. This is in some ways also creating some further impact in the process, because it's in some ways may potentially delay further the process of enforcement in some cases. Again, this takes us back to DMA. Some of the issues why DMA established more clear-cut obligations is to reduce the scope of the debate. If it happens that in a one or two case you have to engage with every single argument the company put forward, relevant or maybe irrelevant, that is cumbersome. If you have already narrowed down the debate to, okay, you have to have a look at this and only this, then obviously some of these elements we see in the case that imply a more potentially procedural obstacles, then of course the scope for that preventing the effective enforcement of the DMA disappear up to a point. But of course, I mean, fundamental rights will be applicable. It is also, I think, we have to make a difference between the DMA part that is about punishment. Of course, I think when we are going to impose a fine, we need to prove the infringement. The type of guarantees you will have will be very similar to those we see in competition law. But you have the whole regulatory part about designations, about the specification decisions, where normally fundamental rights are not engaged in the same way. And I think possibly there we will have maybe I wouldn't say more freedom, but somehow the development of case law that is needs to engage a bit less with fundamental rights, and it will be a more typically regulatory function where the authority in somewhat technical matters maybe up to a point is given some leeway to decide, because I think generally speaking the trend towards very more exhaustive judicial review, it's mainly again in cases where you have a punishment, as opposed, for example, to mergers, where eventually it's still, I think, case law by and large gives some leeway to the commission. So I would expect maybe some parts of the DMA would be subject to a judicial review that is for more similar to the merger one, rather than the antitrust, where because it's quite a criminal somehow we impose a sanction, you engage more with fundamental rights, and therefore also the standards tend to be higher.
And in this regard, I think it resonates very well with what Pablo Ibanez Colomo was talking about when describing the DMA, that the drafters or the co-legislators have embedded into the system more flexible rather than more clear-cut, as you say, the self-executing. In addition to being self-executing in some respect, you have the more informal ways, say regulatory dialogue, to shape pro-competition regime for digital market, whatever, to shape the future digital European digital markets. Where would you say that the evidence of this judicial regulatory dialogue or other informal or quasi-formal means of communication with gatekeepers in terms of eventual opening the proceeding on non-compliance, where do they become justiciable? Where would they be able to trigger the fundamental rights mechanism, saying that the commission is biased and they somehow prejudge us, etc.? Do you think that it's possible to set up such minimum threshold above which it's advisable not to move in the regulatory dialogue?
It is indeed a tricky issue, because I think when the commission is facing a possible case of non-compliance, theoretically you can go into the non-compliance mode, so to say, but you can also engage into an Article 8 specification decision. You could say, okay, there is an issue here. I will tell you what you have to do, and that's it. Maybe in dialogue with the undertaking. It's difficult to see. I mean, to me, in principle, to see that these choices of going more into one mode than the other engage necessarily with fundamental rights. Certainly, you go into the non-compliance mode all the way to impose a fine. Yeah, I think fundamental rights will play a very important role. At the same time, I don't think companies will complain, gatekeepers will complain if you go into the more regulatory mode, because that is to their advantage somehow. They may avoid a fine if they get some guidance from the commission by way of specification decision, and the more informal dialogue you may have, of course. I mean, you may eventually, I mean, when there is a conversation with the gatekeepers, we tell them, we give them feedback about, what you're doing, we think it's in principle wrong, etc. So there is a more informal way of, I don't think as such that is a problem. I mean, there is always the issue, and I always say, we have to be careful when we talk about non-compliance in general. Presumption of innocence implies that you have to be careful. Say, well, this is on a provisional basis. So you cannot just say, I have made up my mind, you're in breach of DMA without having done the proper procedure. That is a general thing. So, but it's difficult. And I think again, these are issues will be coming up in the sense we will have situations where we'll have to decide, okay, is it worth going into a proper non-compliance with all the, guarantees that it implies, or we can just go into a specification decision. I mean, they're thinking aloud. It may have to do with many criteria. You may have to, the attitude of a gatekeeper is very important. You have eventually the impression some gatekeepers are very difficult on some issues. And yeah, going to a specification decision may not be enough because they may challenge it, because they're not very cooperative. It's better to go the full mode of non-compliance, which appears to be really the stick, the harder stick. Huh? In some other cases, there are genuine issues about, or some gatekeepers appear to be more open to have a conversation with the commission, therefore more open to engage into the sort of specification type of decision. And that is a better way out because, they want just to, they want to be clear about what they can do and they cannot do. And a specification decision will tell them, okay, no, to comply with this, you do this, this, and that. Huh? The specification decisions are there because there was the realization that for some obligations in Article 6 and 7, there could be, from technical side, some discussion about how to do it. Maybe there is more than one way to do it. Huh? Therefore, I have the impression that in the future, we possibly will see both things. It's also a question of resources, of course. Huh? A non-compliance proceeding possibly involves more resources, even if what you have to prove is not the full competition case. Huh? Whereas a specification decision, if it's done in cooperation with the company or up to a point in cooperation with the company, will be less resource intensive. But I think in principle about the choice fundamental rights, I'm not sure they play as such a role. But if you go for the non-compliance, then what happens is that fundamental rights will be more prominent in the procedure, and therefore this may be an aspect that will eventually be considered in order, because that implies more procedural guarantees, potentially more time, depends on the case. So it's something that may have to be considered, but I'm not sure it really there is a right to one procedure or the other. That is a bit the unusual animal we have in DMA. That is a mixture of regulation and also, of course, compliance, and later on, of course, a possible sanctioning. But we're still in the process of thinking about these things. We're still early on in the process. People talk a lot about the future, and I understand that and how they see things, but we are still in the early stages of compliance. And with the obligation just were triggered 2 months ago. There are a few cases pending, and some of these issues that you're mentioning indeed are in our minds when we discuss some of the cases.
I'm mindful of time, Fernando, but kind of just temptation to ask you your view about private enforcement in the DMA. Because again, some people say that, well, it will create fragmentation, or some critics, let's say that it creates fragmentation, and then other type of critics would say that it decreases the competence of the Commission to be a powerful, as kind of bargaining chip in regulatory dialogue, because you can achieve the same through backdoor, and it inflates somehow the entire mission of the DMA, because it creates easy opportunities for those at the extreme rent-seeking, third-party funded companies who would easily establish instances of non-compliance, or maybe relatively easily.
Yeah, I think it will depend how it develops. I mean, there will be some degree of private enforcement. This is a regulation. There is some debate about how much, about Article 6 specification decisions you need or not. I personally don't have a strong view about that. I think we will have, in the theory, how possible it is. I think it's only when we start seeing serious litigation at national level and preliminary references, and I'm sure they will come. They will have to define a little bit and think more about it. At the moment, I have to say, this is not so much in our minds, because our minds are focused on, compliance cases by the Commission. What happens at national level is not so much in our radar. We hear about maybe a possible case here or there, but it's not so present in our mind. So I think there will be some. Whether it will interfere with the Commission's being the sole enforcer, we will see. I think, of course, you have all the masterful case law of the ECJ on, the Commission's decisions and being, in the drive seat of competition law has an impact on what national courts can do. I can perfectly imagine that there is some duties of loyal cooperation. If it happens that the Commission is investigating something, then it may be logical. And the good thing about DMA, you have some indicative deadlines. So if we are investigating something, you can expect in a year's time you will have an outcome. Maybe the good thing to do is for the national court to stay proceeding, for example. So there will be for sure the court will have to develop some elements of cooperation there. I think this cannot be just the national court that do whatever they want, ignoring that there are pending procedures here in Brazil. But of course, you will have the cases where eventually the Commission hasn't opened an investigation as well. And you could say, well, I mean, in that case, the fact that not opening doesn't mean that it's all fine. We were talking a bit before about being selective about the cases you do. It may well be we haven't opened a case because very simply, we have decided to give priority to other situations. And in those cases, I think there will be some degree of enforcement. I think how the case law will develop, it's difficult to predict, and how it will develop in general. On the one hand, the ECJ will be mindful, I think, of the more prominent role of the Commission in enforcement. At the same time, the ECJ is extremely damages friendly. So if you have a look at all the recent case law on private enforcement, the last one being the Eureka judgment, or the Czech case of the Grand Chamber of the ECJ, the case law is very, very friendly towards private enforcement as well. So I can perfectly see the ECJ having a rather friendly attitude to private enforcement, thinking that is good, generally speaking. I think in general, the court has been at the forefront of recognizing the importance of private enforcement in the development of EU law. Even had some cases recently, precisely 2 years ago, the judgment only a transport about whether it was at all possible to get damages before actually the Commission had the power to enforce a competition on in-air transport, and the court said yes. So it has been very friendly towards private enforcement. Huh? So the risk indeed is that the lots of private enforcement that doesn't take into account. I don't know how these things will develop. I think on the one hand, I think the court will be friendly towards private enforcement. How much we will see. On the other hand, I think the Commission will be mindful to defend its role, in particular in cases where it is actively investigating, because otherwise you may have situations where there is an interference between the two levels. And that is, I think, a bit dysfunctional when you know that you have a legislation like DMA that establishes some indicative deadline, which means that you don't have to wait for 5 years, yeah? And then you have a case pending in court that may be a bit strange. So I think, again, possibly the outcome will be somewhere in the middle, where some degree of private enforcement will exist, will be tolerated, even encouraged by some case law. At the same time, I think we need to be mindful of not interfering too much with the cases, in particular when the Commission is actively investigating. Yeah?
Thanks, Fernando. Let us finish our conversation with traditional question, recommendations to students. You see how competences and skills change of those who start their career in this area, let's say, regardless of which side they take or which trajectory they select. Maybe there are some skills which you see that most of newcomers in this profession are missing, and they are of greater demand than they were in just a few years ago. Maybe the universities have not absorbed yet these new elements which are missing. If you see some, and also if you have any good idea for a PhD research, or something which will become more vibrant and impactful in let's say in 3-5 years time. It's crystal ball gaze, but we are in this crystal ball gazing area.
Oh, well, PhD, I didn't dare to say anything about that. I need to think more about that. In terms of students and careers and skills, I do a lot of recruitment because my team is the youngest team in the legal service. So I'm possibly the team that does more recruitment. So I see lots of CVs. I do lots of interviews with mainly younger professionals, so to say. Yeah? Maybe a couple of issues there. There is this, for example, when I look for someone, particularly in the legal service, as opposed a bit to the competition, we're looking for lawyers who are good in competition law, but they're also good lawyers overall. Why? Because we have a system of rotation, and you have to be, there's a lot of competition bubble. When people just do competition law, they don't read anything but competition judgments. They don't make links with other areas of law that are very important. And competition law is part of the wider legal system. You cannot really just know about competition law and forget about, well, we're talking about enforcement. When we're talking about enforcement at national level, you need to be familiar with civil law, with even constitutional law, fundamental rights. So really it is within this wider system of EU law, and even to know more about the fundamentals of national law. So I tell everyone, even if you want to do competition law, you really do something else for a part of your career, because you will learn many things that otherwise you will be missing. And you will be making links with other areas of law. I was explaining before, it's thanks to the experience I had by doing other stuff that you're more helpful in drafting legislation concerning, for example, DMA, because you have ideas about how to do certain things that people who are just competition lawyers, if doing just competition law, will not have. And because it is important to go beyond the skills of just competition law and to be a rounded lawyer overall, I always also advise, legal education can be a very long one, but it's worth it in the sense that I see every now and then people who start to, build the thing from the roof, study European law without having studied national law. And to me, it is quite important to have, EU law comes on top of national law. EU law is an incomplete system. It doesn't have its own enforcement mechanisms. It relies on national law. it lacks some features of a full system of law. And therefore, one needs to well understand the national law, to have an education in national law, constitutional law, to know what a contract is, what is a constitution, etc., to better understand also and enforce EU law. So I see every now and then people who are just studying EU law, and to me that is a bit lacking in something, because later on when we have to discuss other issues wider about the law, which of course they come from national law very often. I said contract law, tax, whatever, things that you may think in national law, they may be lacking that. So I always say, look, I mean, it takes a long time, it takes much longer, but try to have a full legal education that covers all the different aspects, not just EU law, also national law. Because that will be also for ourselves much more useful for ourselves. I mean, the legal service, normally we're trying to look for lawyers who are very solid legal education, not too specialized in competition law either. While being good competition lawyers, a solid background in competition law, you can do other stuff as well. There is also one skill which is very important for competition law, which is to be willing and able to engage with non-legal issues. And one of the things I love about competition law is that I learn so many things about things which are unrelated to competition law. I have a case in air transport, and then you understand how air transport works, the hubs, etc. You have a case in the pharmaceutical industry, and then you learn how some drugs work in your body, and so on. So you learn about many things which have nothing to do with competition law, because you have to apply. You have a merger or a case where it requires you to understand a little bit the mechanics of the market. You have cases like Google AdTech, which are very technical. We as lawyers, we need to convey the arguments to the judges, and for the judges to understand, we have to understand ourselves a little bit how the market works. And I find that fascinating, because you learn about many things which are non-legal. So I think one of the skills which is important for anyone who wants to do competition law is to be willing to not just to develop great theories about competition law, which in the abstract, but also be very hands-on and willing to learn how a market works, and of course to digest vast amounts of evidence as well. Sorry, I was a bit long.
And they have to speak French.
French for the legal service is quite helpful, because there is, as you know, the court works in French. Many judgments are not available in English, are maybe available in French and the language of proceeding, in particular in the general court. So it is extremely helpful to understand. You have to read and understand spoken French. I have a number of colleagues who never actually speak actively French, but they can read the judgment in French. So the passive knowledge, so to say, for us is a requirement. And honestly, if you want to be serious about doing competition law and be able to read all the case law, you have to read French, because there is a vast amount of case law which is only available in French. Not, of course, the big judgments of the Grand Chamber of the ECJ, but certainly we're talking about evidence. There are lots of evidence issues which are hidden in the judgment, and the judgment is available only in French and Italian, or in French and Spanish, or French and German. So that is important, and we have to be mindful. I have noticed it every now and then, that the English version of some judgments is not ideal for a number of reasons, logistical reasons. At the court, it's not easy to find very good or enough translators. We had two incidents last year where actually two judgments had to be subject to a sort of corrigendum, had to be corrected, because the translation of two paragraphs were just wrong. It was not just even a matter of nuance, was just incorrect. So I always warn again the risk of giving nowadays competition law English is the language, being careful and eventually compare with the French version, because it may happen that there is a nuance that you are making a lot of fuss about it in the language. Oh, but there is this word in the English version, and then you have a look at the French version. It's slightly a nuance, maybe slightly different. I think it's good to understand, because you will meet a better EU lawyer, because you will have access to the original language of the deliberation that will normally convey what the judges really wanted to say, rather than English that sometimes, every now and then, may convey a slightly more a different thing, or a different nuance that is maybe present in the French version that is lost in the English one, or the other way around, actually, which is a problem, because sometimes I've seen people, over analyzing a paragraph in a judgment in English and 2 or 3 words, but actually those words are not in other linguistic versions. Huh?
This is amazing, and I would continue this conversation. It's a real intellectual pleasure to learn from you, Fernando. And I'm glad that we have tentatively agreed to have a panel with Pablo Bani-Colombo and Heike Schweitzer. So we will reconvene at some point later this year. But I hope we'll have a chance, because life expectancy is very long, 100 plus. The DMA is a long business. I hope we'll have a chance to meet in 2025 or 26 to reflect upon the first years of its real function in practice, so to say. Fernando Castillo de la Torre, thank you very much indeed for this very fascinating, very informative conversation.
Thank you. Thank you very much.